Hello, good morning, good afternoon, good evening. I hope you're all doing well. It's 20 past 4 here in the UK. I thought I'd do this trial recap a little bit later today, given that it's Saturday and there's no trial, just to see whether I could get like a handful of more people actually watching, because oh dear, no one's watching these trial recaps. No one. But there's so many people covering the case. I get it. I understand. Hello, Angie baby. There's only you in chat as well. So maybe this time ain't great for anybody, let alone the few people who've been watching my trial recaps in the morning. But we're going to do day 4. Actually, day 3 was a half day, because Brennan cocked up his witnesses. And then yesterday was also a half day. I got it completely wrong yesterday. I thought they were doing the jury review in the morning and then it was going to be ARCA in the afternoon. But I was told, and you were right, that ARCA is on Monday. So the voir dire for ARCA is on Monday. But I just assumed, because ARCA wasn't coming on Friday, that it was going to be the jury review and nothing else. But no, there was 2 witnesses, not long witnesses, and we're going to talk about one of those witnesses. We're going to talk about just a little bit about the jury review. Karen's Lexus, which was parked there outside of 34 Fairview for the jury to peruse. And then we're going to talk about the blood content person, the blood alcohol content person, like a doctor who was at the Good Samaritan Hospital when Karen had her blood taken. And we know from the trial last year that her blood alcohol content was still quite high. It was still over 0.08 at 9 o'clock in the morning. So this would have been 9 hours after Karen stopped drinking. So they did this calculation as to what her blood alcohol content would have been at like 12:30. And it was like a wide variation from being like moderately high to mega high. Now, we've not got there yet in this trial. So this witness was just talking about the blood draw. And I thought Lally did quite well. It's the first time we've seen Adam Lally strutting his stuff with a witness. You know, he did every single witness last year, and he was very, very, very boring. Like, Judge Canoni had to keep telling him to keep his voice up. He was just like muttering to himself a lot of the time. But yeah, he was a little bit more animated. So I don't know whether Brennan's been giving him some training or whether it's because the heat's off him because he doesn't have to do every single witness. But he was a little bit more animated. And I thought Lally actually did quite well with the blood person. And Elizabeth Little, who's one of the defense attorneys, who herself doesn't get a run out very often. I don't know whether the point she was making really hit home, honestly. I'm not sure. I get what she was going for, but I'm not sure that it was dead effective. And then the final witness was another EMT. And I'm not going to talk about him because he basically said the same as what the previous one did. So he's the Jason Becker. He was one of the EMTs who took Karen to hospital. So we heard from Whitley, and we've now heard from Becker, who was Whitley's partner of that night. So I'm not going to talk about him because there was nothing new. I don't know what Brennan's doing. Like, he seems to be like jumping. Like, he clearly has a plan about, you know, specifically the order of the witnesses and exactly where he's taking the jury. But I'm not seeing it at this moment. If I was a juror, I'd feel that he was jumping around a little bit. You know, like we're going from EMT to witness to blood person to another EMT, and it doesn't seem to be gelling quite yet. And then these stupid clips. At least we didn't have any stupid clips yesterday. But I did think that it was a reasonable day for the prosecution yesterday. I certainly don't think that the prosecution suffered in any way by the half day. And I think probably, potentially, they scored more points in the jury's eyes than the defence did yesterday. But we've got a long, long, long way to go. And I may be way off the mark with the way I'm thinking. I'm just trying to put myself into the mind of a juror in saying these things. And I think if I was a juror, I think I'd have been more satisfied with the prosecution's performance yesterday than the defence. But we'll see. We'll see. All right. So I'm going to start with the jury view. And before they went out to the jury view, they were allowed, Brennan and Unetti were allowed to give a little speech as to what they wanted the jurors to see. So the jurors were instructed by Judge Canoni that they were allowed to use what they saw, what they observed in their deliberations when we finally get there. It was something that Bev Canoni stressed was that they can't do their own investigation while they're there. So they can't start taking photos, they can't try to do measurements. Not that they're there with a tape measure, but, you know, you can measure things with your feet. You know, like the word foot comes from somewhere. Like in the old days, a foot was the length of an average man's foot. I still measure. Listen, when I've got to measure anything, I measure it with my feet. So, yeah, because my feet are about the size of an average man's, because I've got quite big feet. But anyway, so you could start walking around doing a rough and ready measurement with your feet. They're not allowed to do that. Okay, they've only got to look at the scene. They've got to observe the scene, and Brennan and Unetti gave them a few clues, a few tips about what they wanted them to look at mainly. And the attorneys were allowed to point things out to them while they were there, but they weren't allowed to engage in dialogue or anything like that. So, all right, we're going to start off here with Brennan. Brennan's little speech.
Yeah,
Please.
thank you, Your Honor.
Good morning, ladies and gentlemen. As Her Honor explained to you, we're going to go to 34 Fairview Road. We have some exhibits that are already in evidence. You haven't had a long time to look at them and study them. But essentially, we're going to go to 34 Fairview Road. I ask you to pay attention to the street, the front yard of the home. And you'll see to the left side of the front yard in the corner, there'll be a car. It's the Lexus that we've spoken about, the defendant's Lexus. And you'll also see a flagpole and a fire hydrant. And so I'd ask you to take a look from different vantage points. Take a look from that area where the flagpole is, from where the fire hydrant is. And you'll see on the street before the grass is a little bar concrete that comes up a little bit. I'd ask you just to note that as you go. One thing I'd suggest is...
All right, the concrete that goes up a little bit. I think he means the curb. I think that's what he means. But let's take a look at 34 Fairview. I call that a curb. Do you call that a curb? Did they call that a curb in Massachusetts? A little concrete thing. I'm guessing he means the curb. So this is the left-hand side of the property, and you can see this house still. Look, go here. You can see this house. Oh, what are we doing here? If we go down the road here, there is a point where you start to see the house. There we go. You have to get it in the right spot. Google hasn't quite blurred it enough. A curb. It's called a gutter down here. Well, the gutter, to me, the gutter is this bit. So like the side of the road. So you've got like the road, then you've got the gutter, like where they put the drainage, you know, like manholes, where they put that. That's the gutter. And then the raised up bit is a curb. All right, not the concrete thing. But there, on the left side of the property, there's the flagpole. It's still there. And the fire hydrant. Where's the fire hydrant gone? There is a fire hydrant somewhere. So that's, oh, there's the fire hydrant. And then there's like this electricity box thing that doesn't look like it's active or whatever. But there's the fire hydrant. So Karen's Lexus was going to be parked right here, where Karen was parked when she dropped John O'Keefe off, and where the prosecution are claiming she went forward about 35 feet. This is what they're claiming. And then she slammed the Lexus in reverse, and then she reversed 70 feet, sideswiping John's right arm, smacking his arm into her tail light, broke her tail light, and then it flings him 8 to 10 feet onto the grass, where he bangs his head and dies right near the flagpole. So that's what they're claiming. So if Hank Brennan starts claiming that he bumped his head on the curb, well, how did he? How did he? Can't believe Michelle doesn't know about this. What doesn't Michelle know about Patrice change? What doesn't Michelle know about? Michelle needs to know. What doesn't Michelle know? Michelle needs to know everything. What doesn't Michelle know about? What doesn't Michelle know? Tell me. All right, you're not going to tell me. Okay, back to Brennan.
April 25th, 2025, January 27th, 2022. So the weather will be very different. The temperature will be different. The conditions will be different. We're going to go there probably at 10 o'clock. It won't be the same visibility. It won't be the same elements and the same colors. Keep that in mind when you're looking around. When you look at the Lexus stuff that they're asking you to look at, there is some evidence already in the photographs of the right rear taillight.
TB's and Chasing Truth's post on community page. Is that what I don't know? Okay, I'm going to go and have a look. Chasing Truth, you say? In a sworn, is this it? Is this what you're talking about? In a sworn affidavit, a protected witness whose name has been withheld states quite a bit about the goings-on in the Karen Reid and Ada Kearney cases. Okay. Who's Catherine Peter? No, I didn't know about this. So you were absolutely right. I didn't know about this. Who's Catherine Peter? For close to a year, I've had multiple conversations face-to-face with Peter. Peter volunteered information to me about the Karen Reid case countless times throughout our friendship. All factual representations below are from what Peter told me about her involvement. Okay. During Karen Reid's first trial, she was in regular communication with ADA Adam Lally. At one point prior to jury deliberations, Peter met with Adam Lally for lunch. During this lunch meeting, Adam Lally told Peter he knows the foreperson. No. Where's the rest of the page? Page 1. Oh, okay. Specifically, the defence had made 3 letter demands for ordered and/or required discovery concerning civilian Catherine Peter, who, on information and belief, is working as an agent for the Commonwealth in their prosecutions against Mr. Kearney and Karen Reid. See letters of Mark A. Bedrow, special, blah, blah, blah. Although our first demand was made more than 6 months ago, the prosecution has neither provided the defence with any of the requested discovery nor indicated that none of the requested items or information are within the possession. Okay. This is all in the wrong order. This is in the wrong order. So the jury foreperson, who is a retired police officer, and he, the juror, is guaranteeing a mistrial. This is what was verbally reported to me by Peter. She told me she paid $1,500 each month via Cash App for her assistance in the Karen Reid and Aidan Kearney prosecutions. Peter believes that Karen Reid is innocent, but she has to play the game. I interpreted this to mean Peter's role is to publicly promote and advocate on social media that Miss Reid is guilty. Peter opined to me, if anyone killed John, it was blank, an asshole. Peter is very close with Hank Brennan and has had multiple conversations and meetings with him. I've personally heard Peter on the phone with Hank Brennan. During a phone conversation between Peter and Hank Brennan, I was present and personally recognized Hank Brennan's voice. Peter told him that her people leaked it to the media, referring to the federal investigation being over. As of April 15th, Peter is not talking directly to Hank anymore. We're using a third party to communicate now, she said. Peter states she is untouchable because everything she is doing to assist the prosecution, and that no matter what violations I'm charged with, Morrissey is keeping me out of jail. Oh, wow. Peter was told by Jennifer McCabe that Jennifer McCabe informed Michael Morrissey that she is not testifying unless Turtle Boy is in jail. Michael Morrissey informed Jennifer McCabe. Dear me, this goes on and on. Look, some of this is not in the right order. Look at this. So that doesn't fit with that. But then this is in order. Okay. Michael Morrissey informed Jennifer McCabe he would have to subpoena her and Jennifer McCabe, then told Michael Morrissey that we won't say. Peter got rid of her phone the day after Aidan Kearney announced on his live show that he was looking to get personal communications of Michael Morrissey. Can they prove it, though? Can they prove it, though? This is the thing. The day that Peter showed up in protest at the Karen Reid trial, Peter informed me Jen McCabe paid me for her show of support. On March 16, 2025, Peter told me that she went to meet with Michael Morrissey and Jen McCabe at an undisclosed location in Braintree. When Peter returned home, she had a manila envelope in her hands. Well, it's not the complete affidavit, but interesting. How can they prove any of this, though? I mean, yeah, fair enough, it's a sworn affidavit, but how do they prove it? How do they prove that this Catherine Peter, whoever she is, knows all of this stuff. And the undisclosed witness who's had this communication with Catherine Peter has been told these things by Catherine Peter. But how can they prove it? It's very interesting. Assume digital footprint. Depends how careful they've been. Well, let's see how all this shakes out. Let's see what gets mentioned on Monday. When was this? Was there a date on it? So this is not for in the Karen Reid case. This is in the Aidan Kearney case, which I haven't been following, but let's see. Let's see. So this claim is that she's being paid $1,500 a month via Cash App. Well, that's provable. They'd have to subpoena the Cash App records, but that's provable. I've personally heard Peter on the phone with Hank Brennan. But unless you've got proof, then... But the Cash App payment, that's provable. Peter got rid of her phone the day after Aidan Kearney announced on his live show that he was looking to get personal communications of Michael Morrissey. Peter said to me, they will never get the communication between me and Morrissey. Ha! Okay, well, we're going to wait and see how that shakes out to see whether anything at all is mentioned on Monday. Is there going to be a request for a mistrial while all of this is sorted out? Let's wait and see. Let's wait and see. All right, going to rewind back to day 4. Let's not get ahead of ourselves. Let's not try to predict the future. Very interesting though it might be. Let's get back to day 4, which is really only day 3 because of the half day in day 3 and the half day in day 4. So we've actually only had 3 days of testimony. But anyway, listen to what Hank Brennan wants the jury to focus on.
When you look at their light, it will be different in the photograph than as evidence. It has been removed, so it will appear differently, and you'll later give testimony explaining that process. Also, I'd ask you to make a note on the Lexus about the height of the bumper. I'd ask you to make note of the height of the right rear fairing. And I'd also ask you to take note of, on the top of the hatchback, there is a part that protrudes. I'd ask you to look at that.
Okay. So he wants us to take note. So that's just a side on view. This is Karen's Lexus. I think this must have been photographed from the view last year. And then we've got this close up. So the height of the bumper. Okay. There's a broken tail light. And then presumably the height of this top thing here. So what they're saying? Are they going to try and say that John whacked his head on this thing? And that's how he got the head injury? Because they're saying that the scratches and the bites on his right arm come from him connecting with this tail light. But how did he get his head injury? So what are they going to try and claim? That the car hit him in the head, or that he cracked his head on this curb? Excuse me, neither of which can be true. Because if he sideswiped his arm on this, how's his head connected with this? And how did his head connect with this? What they have to prove is that John O'Keefe being sideswiped by his right arm, even though it didn't cause any bruising, any broken bones. He'd have had dislocated shoulder, presumably. But no. And then he lands near the flagpole. Taillight bites, who knew? I know. So that's what Hank Brennan wants them to look at specifically. So Hank Brennan doesn't do anything without a plan, because he's a conniving little shit. So bear in mind, these things are going to come up later in testimony.
Thank you very much.
All right. Thank you, Mr. Brennan. Mr. Yannetti?
Thank you, Ron.
All right, let's listen to Yannetti now.
Good morning. As I told you at the start of the trial, my name is David Yannetti. I have an office in Boston and in Denver. And on behalf of my co-counsel, we will be accompanying you on the view that you will take today. Although the view is not evidence, I suggest to you that you will find it to be helpful, important, even necessary as you later do your investigation of this case within the four walls of this courtroom. You've already received in evidence, some photos and videos, but there is no substitute for your own two eyes. As we all know, photos and videos sometimes can be misleading in terms of relative distances, depending upon the perspective from which the photo is taken. But your eyes are the best computer that you could bring to the view. When we get to 34 Fairview, we will be pointing out certain things that we'd like you to observe. The house, the second floor window to that house, the three front doors in the front of the house, the driveway, the street, the front lawn, and the flagpole.
Okay. All right. So the reason why he wants them to take note of the second floor windows is because Brian Albert and what was her name? His wife, Nicole Albert, I think. They were sleeping in one of these rooms to the front of the property. So they can't say, well, we didn't hear any commotion or see any lights or anything because we were sleeping in the back. Because they weren't. They were sleeping in one of the rooms at the front. So they slept through it all, apparently. Okay. 3 front doors. Is there? 1, 2. Where's the third? I suppose the garage is a door. And then you've got the gate. You can go through this gate to get in the backyard as well. So the driveway, the front yard. It's not a big yard. It's not like an acre long driveway. Right? John O'Keefe is right here. And according to the prosecution's case, John O'Keefe has been right here since 12:32, and all of the people coming and going, leaving the party, John O'Keefe was there the whole time. And he wasn't completely covered in snow when these people were leaving, because the blizzard only started to kind of get strong as the night progressed. Like it was just like flurrying and stuff at like 12:30. So how did no one see him? How did no one see him when they came out? Whether they came out of this door, whether they came out of this door to get in their cars to leave, how did no one see him if he was here the whole time? That's what he's getting at, isn't it? Okay.
And we'll be asking you specifically to consider the distance between that second floor front window and the front lawn. The distance between the front doors to the house and that front lawn. The distance between the driveway to the front lawn. And we'll be asking you to take a good look at that Lexus. Just stand next to it. Just size it up. Take it in. You were all selected as jurors because the parties entrusted that you would do a proper investigation of this case within this courtroom. On behalf of Ms. Reed, we have every confidence that you will triumph in this investigation. Thank you.
All right, jurors, I have to make something very clear. So the purpose of this view is to help you better to understand the evidence that you'll hear during the trial and to help you appreciate the location and its surroundings. The view you'll take is part of this case. The observations that you make while on the view may be used and considered by you in your deliberations in reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations. Also, while you're in the view, the same way you're not to take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look, okay?
Okay, cool. Good for her. Good for her. I know when they stand in front of the jury, they need a lapel mic on. Like they're not near the microphones. And lapel mics are really cheap. They could just pop a lapel mic on when they stand near the jury. I don't know. It would be too simple, wouldn't it? All right, we're going to go to the blood guy now. So there's a long break while they're at the view. And then the get blood guy. All right, so I'm not going to play the direct. So he's basically explaining who he is. He used to work at the Good Samaritan. He doesn't work there now, but when John O'Keefe had his fatal whatever it was, John O'Keefe was taken to the Good Samaritan. And then, a few hours later, Karen, under a Section 12, was also taken to the Good Samaritan. And they took her blood and they measured blood alcohol content. So we're going to come into this during cross-examination. So let's not split it up.
A competency. We have to always make sure people know what they're doing, and it's a CLIA or a federal government regulation or requirement. So when anybody first starts in a hospital, the requirements are: one, initial training. You can't let anybody come in on their own, without not knowing what they're doing. So we have to document that they have the initial training and they're competent. And
okay, so everybody's competently trained, and the lab itself, where the blood is tested, is accredited. But once under cross-examination, we learn that the lab at the hospital isn't accredited for forensic testing, that their lab is accredited for clinical testing. So when they test someone's blood, they're testing the serum, the liquid, right? That's what they're equipped to use, and they're accredited for that clinical testing. However, for forensic testing to be, for a sample and a result to be admissible in court, there's an extra level of accreditation that's needed, which we find out under cross-examination, if we can get to it.
The significance happened with it.
5 minutes from that, we've never had the forensic accreditation, but we have very good quality lab results, which I could go into further.
But you've never been accredited by a forensic accreditation team, right?
No.
And the lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
No.
Are you aware that ANAB is the forensic accreditation?
Now, this dude is a clinician. He's not a forensic scientist. And the lab at the Good Samaritan Hospital, although I'm sure it's very good for clinical testing, it's not accredited to take forensic samples from. So what Elizabeth Little is arguing here is, this is a really good point that she's making. This is a really good point. But when she gets into the nitty-gritty in a minute, I think she loses. I think possibly, potentially, she could have lost the jury a little bit. And this guy irritated the hell out of me because he was like, and he was clearly a little bit nervous, but he does stand his ground once she gets into the specifics.
Accreditation body that in the United States that ensures that laboratories' procedures meet the minimum standards necessary to ensure results are reliable and credible for use in court.
Sustained.
And why was that sustained? Like, it's so annoying. So annoying. The fact that this lab doesn't have a forensic accreditation, and therefore there's a question mark as to whether anything taken from that lab should be used in a court case. Oh, but she's not allowed to continue that. Okay.
Now, the most reliable method of forensic ethanol testing is called headspace gas chromatography, or HSGC. Are you familiar with that process?
Yes.
And HSGC is the method that's used by forensic labs to test for blood alcohol content, right?
Correct.
And that's because forensic tests require the testing of whole blood for the presence of alcohol, right?
Correct.
Can you briefly, just for the jury, describe sort of the difference between a whole blood test and a serum test?
Sure. So whole blood, to put it simply, when you have your blood drawn, you see the fluid coming out all red. That's whole blood. We don't do anything to it. We don't spin it down. We don't centrifuge it. That is whole blood. That is the specimen of choice for forensic blood ethanol testing. Hospitals, on the other hand, our methodology, which is just as good as the forensic headspace gas chromatography.
Yeah, it might be just as good for clinical measures. However, blood, just testing the liquid, just testing the serum, gives you a higher blood alcohol content than it would do if you're testing the whole blood. And he admits this. So the test itself might be just as good, but it gives an inaccurate reading. Now, this is what the defense is going to, I suppose, hope that the jury pick up on, is that once they start talking about Karen's blood alcohol content, because this guy is just talking about how the test's done rather than the actual content itself, like the measure itself. The defense will argue that the blood measure sounds high, the blood content sounds high, but there could be a 10%, 20% inaccuracy, that it could read 10 or 20% higher because of the way that it was tested at Good Samaritan than it actually was. And that's a good point. But I think if I were a juror, right, and I'm trying to think about this as a juror, not someone who already believes Karen's innocent, as a juror, I would be really suspicious of the defense trying to downplay, because it's clear what they're doing, downplay the blood alcohol result, because Karen herself admits that she's been drinking. So I hope that the defense don't over-egg the pudding here by trying to say that Karen really wasn't that drunk. I think they should admit that she was drunk. I think they have to, because of the things that Karen has said herself. She said that she shouldn't have been driving. I think they have to admit that. And I hope they don't over-egg the pudding by trying to convince the jury that she really wasn't drunk. Likewise, I hope they don't over-egg the pudding regarding the relationship by making the jury believe that Karen and John's relationship was perfect, because it clearly wasn't. So there's a way to keep the jury measured and keep the jury on side by saying, yeah, the relationship wasn't perfect. There were arguments in the relationship. However, there was no motive for murder. And it's clear from the text messages that we saw yesterday, day 3, that John did not want to break up with Karen. So there was no motive for murder that the prosecution is trying to claim. They're trying to claim that Karen's motive for murder was because John wanted to break up with her, and then she was mad with him and she spied her chance to get rid of him. It's absolute nonsense, because there's no reason to believe that John wanted the relationship to have ended. John comes across as a little bit of an arsehole, actually, in those text messages, as I talked about in the last trial recap live stream. And I hope that they acknowledge, I hope the defense acknowledge and don't lose the jury by trying to say that Karen wasn't drunk, because by her own admission, she was, and she shouldn't have been driving. So, but just because she'd been drinking, it doesn't give her the motive for murder. And if they can hammer home that no motor vehicle collision happened, that John O'Keefe's death was not due to colliding with a motor vehicle, then they're home and dry. But they could easily lose the jury with these small things that need not happen. That's just my opinion.
Is based on looking at the serum or the plasma. So we don't, that's what when I explained that we need to centrifuge it, take the liquid portion off the top.
They were all over the legal limit. They were. And John was encouraging Karen to drink more. Like in one of Karen's media interviews, she said, oh, well, the vodka wasn't that strong. And John, was getting shots for her so she could tip the shots into the glass. So John was relying on Karen for his lift, and yet he was encouraging her to drink more. Not that she should have, I'm not excusing it, but he as the cop didn't have a problem with her drink and driving.
So in the hospital, we tested on the serum or the plasma. Now, did you ask me the difference? You want me to go into the difference?
That's enough, Doctor. Thank you. I'll ask some additional questions
Okay.
to kind of clarify. And in a forensic lab, they actually require the testing of whole blood, correct?
Correct.
And HSGC directly measures ethanol in the blood.
Correct.
And this method is designed to be accurate and reliable for forensic purposes for use in legal proceedings, correct?
Correct.
But the testing in this case was performed using the hospital's clinical chemistry machine instead of a forensically defensible method like HSGC, right?
Correct.
And that clinical chemistry machine performs what you just testified to, a serum test, right?
Serum or plasma?
Serum or plasma. And hospitals use serum or plasma testing because it's actually quicker and more efficient than HSGC, right?
Yes, it's less labor intensive. It's easy.
Would that make her guilty of a lesser charge? If they charged her with DUI, then yes. She'd have to take the DUI. Now, the way that the lesser charges relating to the manslaughter are worded, I think they all relate to her causing some kind of injury due to drinking. So they can admit she was drunk while still maintain that she did not cause any injury to John O'Keefe.
Easy to automate, but at the same time, very, very good and very accurate.
But serum testing does not actually measure alcohol directly. It instead measures the presence of what's called NADH, right? Yes, I'll repeat that. That was my fault. Serum testing does not actually measure alcohol directly. Instead, it measures the presence of NADH. Is that right?
Almost.
Well, NADH is a byproduct of alcohol, right?
Correct. I can go into the testing methodology that we use to explain it if you want me to.
Well, serum testing measures the presence of NADH, correct?
It measures the rate of change of NADH production, so it doesn't actually look at just NADH, and it measures the rate of production, and I can go into more detail on that.
How does it though? If you just take, this is what I don't understand, and I'm a bit confused by this. That if you just take one blood measure, if you just take one measure, so you take one blood draw and you test it, how can you measure the rate of change? Because you don't have a baseline. So I don't really understand what this guy's on about here. Now, maybe that's because I've completely misunderstood, or because I just don't know anything about this area anyway, which I don't. But if you're measuring the rate of change of something, you have to have at least two measures, don't you? So if you only take one sample of blood, how can you measure the change of it? Because you don't have the baseline. So I don't understand this bit of the testimony. And if I don't understand it, I'm not sure the jury will understand it either. And if the jury don't understand it, they'll disregard it. It'll just go over the head and they'll disregard it. So I don't think Elizabeth Little did a great job here in keeping the jury, because it got really confusing and the questions didn't help here.
Alcohol testing in the lab is correct.
I'll ask you some additional
Okay,
questions
sure.
about NADH and we'll
Sure.
get there.
Yeah.
So you can do this now, but let the doctor answer his question fully. Next question, okay? And the following questions.
Doctor, the higher the NADH in a patient.
Oh yeah, absolutely. She's guilty of. I think they should have like DUI. Absolutely, she's admitted it. But anything else, no.
System, the higher the serum test result, correct?
That may not be correct, no. It's a rate of change of NADH production based on our methodology. I can go into that. So
I kind of wish you would, because I don't understand how you're measuring rate of change when you've only got one sample. I don't get it. Did a breath test get done at the scene? No, there was no scene, because she dropped John O'Keefe off at 12:31, according to the prosecution. And it was only at 5 a.m. that she realised that John hadn't come home. And the cops only got to the scene around 6 a.m. And then when they did her blood test, that was 9 a.m. So you're looking at 8.5 hours after she stopped drinking. So there's no breath test given at the scene. What they're using is the blood alcohol measure that she had at 9 a.m. and they're extrapolating it based on that measure and what her blood alcohol content would have been like 8.5 hours previous. But how do they know that she didn't keep drinking? Like, Karen has done herself absolutely zero favors by doing those media interviews, because she'd said in those media interviews that she shouldn't have been drinking, that she was buzzed. She wasn't really drunk, but she was buzzed, and she shouldn't have been drinking and driving. But there's no objective measure of it at the scene. We don't know how drunk she was at 12:31 when she dropped John O'Keefe off. Because if you were really clever, you would say, well, I carried on drinking when I got back to John's, and that's why my blood levels were high at 9 a.m. because I carried on drinking on my own at John's. And there's no way anybody could disprove that. That's what I would have done. That's what I would have done. I'd have said, yeah, what I was bought for me at the Waterfall bar, I didn't drink. And the reason why I've got a high blood alcohol content at 9 a.m. is because I carried on drinking because I was pissed off. And I got myself completely blotto when I got back to John's, and I passed out. That's what I would have done. then again, I'm not in the dock, am I?
Our test system is a little bit different than the forensic testing system, but it's also very good and very accurate, and almost when we compare our methodology to the Headspace, we get the exact same results, and when we compare and with peer laboratory comparisons. But what we do is and I think the jury needs to know this. Maybe some of you might understand the chemistry behind it, but we do.
No, well, I don't understand the chemistry behind it, and unless you're an actual chemist or a biochemist, I don't think you are going to understand the chemistry behind it. So Elizabeth Little should have stopped him and made him state exactly what she's trying to get at here in simple terms, and not leave anything confusing, because I'm confused by this. This is why I don't think Elizabeth Little did a great job, that it would go over the jury's heads, because it went over my head. I have to say, I don't understand how they can measure the rate of change of anything when they only have one sample. Oh no, she wasn't the only one drink driving. They were all drink driving. Absolutely, they all were. But she's the one that has to defend her actions. How is this allowed anyway, since they're not forensically accredited? That's a good point. That's a very good point. Why are we even having this conversation anyway? If this wasn't done in a forensic lab, how can we trust the figure anyway? But again, that's down to the jury to think how important is that.
We take the patient's sample, and it's based on we add, because when there's alcohol in the specimen, we add, actually, in the test system, alcohol dehydrogenase. It's the same enzyme that's in the patient's body. In addition, we add a surplus of NAD to it. NAD is similar to NADH. They get converted back and forth. So when we put it on our test system, it's alcohol dehydrogenase is in there. And what happens is, when there's alcohol, it combines with NAD that we add to it. It creates NADH. And then in our machine, there's a spectrophotometer, which can monitor the rate of NADH production over baseline.
Oh, okay. So all this is being done during the test. Okay. Listening to it a second time, I'm understanding it now. They actually do something to it. They put something in the blood so that they can measure the rate that things are changing in that blood. So I understand that now. However, I've got the opportunity to listen to this more than once and to be thinking aloud, like talking to you guys, thinking aloud. The jury don't have that luxury.
And we use...
So again, I think this went over the jury's heads, and that's not a good thing. Never a good thing.
There's something that measures, and a photometer that measures the NADH production. It looks at light in this physics and looks at 340 nanometers, and it's pretty accurate. It will monitor. It will tell you, it will tell the system how much NADH is produced, and that amount is directly proportional to the alcohol in the patient sample. So it's a very, very accurate test, but there are some limitations that I can go into.
So wait.
Okay, let me break this down. So if it gives you an NADH thing, is that the final result? And how is the rate of change being measured? I can understand what he's saying, that they put things to it and it measures how it's breaking down, like it mimics alcohol, or it mimics the body breaking alcohol down. But how do they get to that figure? And how is that figure then communicated, like, to us? What does that look like to us? So I'm still confused. I'm still confused. And Little is just letting him talk. And look, she's an attorney. She's not a chemist. She's not a biochemist. She's not a doctor. So maybe she doesn't fully understand it either. Now, maybe they're going to have to get their own expert to explain this, possibly. Maybe they will, I don't know. Otherwise, this is pointless because they've lost the jury here.
Wait for another question.
Okay.
Next question, Ms. Little.
Yes, so serum testing can be subject to errors, right? And there are limitations.
There are some limitations that I can explain, just like head-space gas chromatography may have some limitations too, but I can go into them.
Next question.
What are some of the limitations of
the
serum testing?
Okay. So the serum test, as with many tests in the laboratory, different things can interfere with our laboratory tests. And the three most common ones, which are unlikely to affect ethanol testing, is we abbreviated HIL. We want to look at those three things. One is hemolysis, which is H, and the other one is I, icterus, which is high bilirubin, and the third is L for lipids. High lipids will interfere with alcohol testing or with any testing based on that same methodology. Our machine, the Rose-Kobash machine, and all the machines out in the market today are very sophisticated. If we have elevated levels of any H or I or L, it will flag it and raise the potential for a problem. The next thing on the list is that our alcohol testing is not absolutely specific for ethanol. There are two possible other alcohols that can cross-react. One is propanol and butanol. But then it goes clinical history. Did the patient ingest those two alcohols? And third is there's some unusual hematologic malignancy.
This is the thing, what Elizabeth Little should be doing. She should be relating this back to Karen Reid, saying, well, do you know if Karen Reid consumed this? Do you know if Karen Reid had a unusually high lipid content? That's the kind of questioning she should be doing. She should be keeping the jury on task rather than listening to all this science. Elizabeth Little should be saying, well, do you know whether Karen Reid had this? Do you know whether Karen Reid had it? And it probably would have been objected to and sustained, but at least that would have been brought up, that at least there would be a question that's relevant to Karen Reid.
Like Waldenstrom's macroglobulinemia, that can interfere. So always have to correlate with the clinical situation. The next one, sometimes there can be patients who make make their own alcohol. So very rarely, some patients may truly have a positive result. That could be from our test or Headspace. They make their own, so we have to rule that out. It's a rare condition.
So you say, well, did you rule that out? Was that ruled out in Karen Reid's case?
And the next one is one that's in the literature, which is LDH and lactic acid. If a patient has a markedly elevated LDH or lactic acid, those one is an enzyme, and the other one is an acid, that can cause false positives.
All right. So is that relevant to Karen Reid?
Now, and
I know that Karen Reid's got MS. And MS patients do tend to have elevated levels of lactic acid.
Stop you there, doctor. I think those were
and actually Elizabeth Little does pull some of this back.
The four that you identified, the four limitations: the lactic acid, the hematite. If I could just
go ahead and ask your next question.
If I could ask you a few more questions about LDH and lactic acid.
Sure.
You're aware, Dr. Fowler, of the medical literature establishing that the presence of LDH and lactic acid can lead to falsely elevated serum readings, correct?
Correct.
And that's because lactic acid, or LDH, actually forms NADH. Right?
Lactic acid, I'll have to go into a little bit of chemistry. Lactic acid.
No. Stick to LDH and lactic acid and make your point, Miss Little. Make your point that MS patients can have a raised lactic acid level. She's lost the jury here. It could have been so much simpler.
And LDH.
And listen, I'm a Monday morning quarterback. I'm not an attorney. I'm not the one asking the questions. I'm looking at this as somebody who's been on the jury and as somebody who normally can follow testimony really quite well. And this kind of lost me. And that's a problem.
LDH, lactate dehydrogenase, they both act on each other. And LDH and lactic acid needs NAD plus to break it down. So in theory, when you're testing a serum, a plasma for blood alcohol, if there's extra LDH or high levels of LDH, high levels of lactic acid, you add it to the test system, and then Roche throws in, or Siemens throws in the NAD, it will form NADH. That was first documented, I think, back in the older versions of these ethanol testings back in the 1990s when they...
Irrelevant. Stop him. Focus on Karen Reed. Stop him doing this.
Stumbled on, they were looking for biomarkers or reasons in kids with SIDS, little babies, and they found that two of these babies had a positive alcohol. But
Doctor, if I could just ask the next question, if that's okay.
Sorry.
So in other words, NADH, studies have found, can actually be formed by certain biomechanical processes other than the presence of alcohol, right?
Yes.
Are you aware that the National Institute of Health has found that liver diseases, kidney diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels?
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
Why? Why? Why was that sustained? That's the perfect question. Why? Why did Judge Bev sustain that objection? If Karen Reed was suffering from anemia, he's already said that anemia can cause dodgy levels to appear. Why was that sustained? Is that word banned by YouTube? What word, Blissful? I don't know what word you're talking about.
Are you aware that the medical literature has also found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
I'm going to allow that.
Oh, thank you.
I haven't read anything specifically related to the NADH level, but but I want to go back to the point where our laboratory, our testing is not based.
Let him finish his answer.
It's not. It's the rate of change of NADH. So if somebody has NADH on board, I believe it.
Tetrahydro isoquinolines. I don't know whether that's banned by YouTube. I can't even say
it's not going to affect the result. It's the rate of change, and it basically.
So again, I don't understand this rate of change. That if you've got these elevated levels of certain things, which he's already said can affect results, why is he then going back on it saying, oh no, it's the rate of change that's important? Because he's contradicting himself, and Miss Little didn't stop him. She didn't say, hold on a minute, didn't you say previously, she is impeaching him here, didn't you say previously that high levels of LDH and lactic acid can affect these results, and that there's certain health conditions that can affect these results? He has to then say, yes, I said that. So then she says, well, how come then you're saying that that's not relevant and that you're actually looking at the rate of change? She could have got him here and she didn't.
Back to the anemia, I haven't read or heard of that.
That was stricken. That was not allowed.
It all goes back to the lactic acid and the LDH. The NADH doesn't matter. So,
okay, so talk about the lactic acid then, because I do know that some MS patients have got higher than normal levels of lactic acid. I also know that some MS patients have higher than normal levels of NADH. I know that because I looked it up yesterday.
Looking at multiple sclerosis patients, they can have elevated LDH and lactic acid, but it's not to the extent that it can interfere with the alcohol levels. There was a study.
Why? You need to tell me why. You need to give me figures. She could have wrapped him up in knots here, and she didn't.
Maybe 7-10 years ago.
Your Honor, There's no question pending.
You asked him about a study, if he was aware of the studies.
I asked, and that's a yes or no question. And he's,
All right, Doctor, we're going to hold that there for you and ask the next question.
Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD through Disease Course in Multiple Sclerosis, which was sponsored by the Center of Healthy Brain Aging by the University of New South Wales? Which,
Do that again and slow down, please.
No, I didn't read that study. However, I asked Google because we know from previous trials that Google, an expert just Googling something is acceptable testimony. But I did multiple. I'm going to do it again. Multiple sclerosis raised NADH level. Okay. AI overview. I hate this. However, in individuals with MS, studies have indicated a twofold increase in NADH levels and a reduction in the NAD plus stroke NADH ratio compared to healthy controls. These findings suggest a potential link between altered NAD plus and NADH metabolism in MS progression. Specifically, reduced NAD blah, blah, blah has been observed in, okay. So nicotinamine adenine dinucleotide and its reduced form, NADH, are crucial, involved in various cellular processes, including energy production and signaling. In MS, studies have shown that serum NADH plus and NADH levels may be altered, potentially impacting disease progression. So twice as high, can be twice as high. So look, if Miss Little wants to do this line of questioning, and it is a good one, and it fell flat here because she didn't quite keep him under control. He went off at too many tangents. She didn't nail him down. I think they need to bring their own expert in to explain this. They need an MS expert to come and explain this.
sure. Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Levels Through Disease Course in Multiple Sclerosis, which was sponsored by the Center for Healthy Brain Aging by the School of Psychiatry at the University of New South Wales in Sydney, Australia, which specifically found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
Oh, there you go. That's where AI got that from. That's where AI got its information from, that study. There you go. Great.
Objection.
I'll strike the part of what the article held. Is he aware of the article?
AI is still too dumb to summarize and verify. Well, they actually came up with the right result in that case.
No, I'm not, to be honest, no.
She should have stopped it there. She should have stopped it there and said, well, how, if we now know that MS patients have twice as high, twofold increase in NADH. How do we know that this result from Karen's blood draw is reliable? Because we've now got its reliability in question in two ways. One, because of the lack of actual forensic testing. Instead of testing the serum, they should have tested the whole blood. And Karen Reid likely has abnormal blood draws anyway because of her MS. She should have got him to say yes to that. And that's it. No further questions. But she does go on for a little bit more. Adam Lally does pull it back a little bit in the rebuttal. So I think Adam Lally did reasonably well here, actually. But I'm gonna stop there because I try to keep these to about an hour just over, and we've gone to 1 hour 10. just in case anybody wants to come and watch this on the replay. As I've only got 75 people watching, I think that's the lowest, 74 now. That's the lowest ever people in a live stream that I've ever done. I think. So people ain't watching these. People ain't watching these. I'm going to keep doing them though. I find them interesting. I'm going to keep doing them. So I will be back to do a trial recap of Monday, which will probably be early Tuesday morning. But until then, I'll leave the Karen Reid content to other people who are getting billions of views. I'm not bitter. I'm honestly not bitter. I enjoy doing these. All right, guys. Thank you for joining me. Thank you, mods, as always. And enjoy the rest of your day. Bye-bye. Bye-bye.